Well, yesterday here on Newsfeed, you saw lawyers for the former President Jacob Zuma claiming that the Deputy Chief Justice Raymond Zondo should recuse himself because Zuma felt he would not be treated fairly by the Commission. But the evidence leader for the Commission, Paul Pretorius, said that Zondo cannot recuse himself because he's actually acting for the President as an arm of the executive, and that this is a commission, not a court of law. Judge Zondo said today he'll announce his decision tomorrow. Pierre de Vos is a professor of constitutional law at the University of Cape Town. Professor, good afternoon to you. Lots of argument yesterday, some of it legal, some of it perhaps slightly different. What is the legal test here? What question does Judge Zondo actually have to answer in this application?
Yes, so Judge Zondo has to answer the following. He has to ask, did President Zuma and his lawyers provide enough facts to prove that a reasonable person, with all the facts, the correct facts in hand, would that the reasonable person fear, would the reasonable person have an apprehension that Judge Zondo would be biased? In other words, that he wouldn't have an open mind and he wouldn't be persuadable once he hears different evidence contradicting evidence. That's the test. And the assumption is that you are impartial as a judge, so the other side must rebut the presumption that there is not a reason for recusal. So it's not an easy test to meet.
Okay, so the onus is on them, not on the evidence leader, not on the judge. The onus is actually on Zuma's lawyers in this case.
Yes, that is correct, because the assumption is, it's an assumption that can be overturned if the other side bring cogent evidence, factually correct evidence, but the onus is on them, yes.
The idea that Judge Zondo should recuse himself because Zuma himself feels that he would not be treated fairly, I mean, does that really work? I mean, couldn't the argument go, and I hate to be so cynical, Professor, but I think we live in a cynical age, frankly. I mean, couldn't the argument go that the former president might say that every judge in the country is biased against him?
Yes. So that is why the test is not how an individual person feels. It is irrelevant whether President Zuma feels uncomfortable, whether he personally fears that the judge is not going to be biased. It is what would a reasonable person think? A reasonable person with all the facts at hand. Would such a person think that President Zuma, former President Zuma, reasonably could conclude that the judge is biased? So that's completely different. It's not in any way what the president personally might or might not believe or think.
And then the argument, and this came up several times, and I think it's frankly what's hanging over this application, that if Judge Zondo recuses himself, it's the end of the commission, that's 700 million rand for nothing. I mean, does that weigh on the judge's decision, or does he only have to make it based on what the reasonable person would feel?
Yes, so this is difficult. I think normally if a judge truly believes that there is grounds for recusal, he must recuse him or herself. But the judge shouldn't recuse him or herself just because there's some worry that there might be a problem. There's actually a duty to continue hearing the matter, even if people might cast aspersions, but it is not actually meeting the test for recusal. In this case, Judge Zondo did suggest that the doctrine of necessity might come in here and say, and it might be necessary to say, even if there is grounds for recusal, there's no other way to deal with this, so I have to continue. That is, in a way, what happened with the Constitutional Court when they had to hear John Sloppy's appeal and they were themselves involved. The doctrine of necessity said, the appeal stops at the Supreme Court of Appeal, we cannot hear it. So it's something like that.
Okay, in the end, this is probably about a couple of different dynamics that are all coming out, and this is sort of where the law meets, I suppose I'll use the word realpolitik. I don't know if there's a word such as real law, you know, spelt sort of in italics, but maybe we can use the word lawfare, might just get us to where we're trying to get to. This is all about what's going to happen in court, right? So you will have, my prediction, I don't have a crystal ball, but my prediction would be that Judge Zondo will reject this application. Zuma's side have already said that they will go to court. So then it comes down to, would he have a strong case in court? And is it really about whether he'd have a strong case in court or just winding down the clock?
Well, I think there are two issues, actually. The one is reviewing the decision, and that can take a long time because you have to go to the High Court and so on. And the Commission is ending at the end of February, I think, beginning of March. So there might be an attempt to run out the clock. But there's another issue, and that is this application might also be, whenever you have a legal claim, there's also a political element. You are trying to convince or educate the public about a certain point of view using the legal process. That might also be the case here. Even if they lose, they might think they win because they have a platform to delegitimize the commission and to suggest to people that the outcome is never going to be legitimate and fair.
Okay. So then, if this is about winding down the clock, and again, sorry that I'm so cynical, but some people have made me that way. So the former president makes application after application, right? The commission starts to run out of time. Judge Zondo has to make findings without hearing Zuma's version. And his team has actually suggested that that might happen, that if Zuma were to testify, he would not answer questions. What happens then? I mean, the deputy chief justice has no version on which to make a decision when it comes from Zuma's side.
Yes, so that is a difficult one because on the one hand, there is the possibility in our law, not previously applied to commissions, but in a criminal case, if you are accused in a criminal case and you don't testify, you don't provide a version, and the other version is credible, then the court can take that into account and they can say, well, you didn't put up an alternative, so we're going to accept the version of the other side. So that might well happen in this case. So President Zuma, in that immediate way, is not doing himself favors by trying not to testify. But of course, then the question will be, and the big fight, that's why I think the big fight is going to be about the legitimacy of the commission and the report that is finally produced by Judge Zondo.
That's fascinating, isn't it? Professor Pierre de Vos, I really appreciate the time. Thank you very much indeed. Professor of Constitutional Law at the University of Cape Town.